The case of Texas versus United States is the latest and potentially most damaging threat to the Affordable Care Act. It actually is one of the weaker arguments saying that the Affordable Care Act is unconstitutional, specifically the individual mandate, but it's the one that politically might have the most steam to carry it all the way through to the U.S. Supreme Court. We'll talk about what's at issue, what the timeline looks like, and who the players are, and we'll give you an update on this case. It is Texas versus United States. It was a case that was filed by about 20 states, both attorneys generals and governors joining, and Wisconsin is one of those states that signed on. It's arguing that the individual mandate of the Affordable Care Act is not constitutional, and therefore the entire Affordable Care Act should be struck. The case went before a GOP-appointed judge, Judge O'Connor, on September 5th for oral argument, and it's now in his hands. The players are these 20 states, the Department of Justice, and then intervener states, states that like the Affordable Care Act and individual mandate that are trying to protect it. Now the plaintiffs, these Republican GOP-led attorneys generals and governors, have challenged the constitutionality of the individual mandate now that the GOP tax bill has become law. Now, the GOP tax bill, you might remember, zeroed out the penalty for being uninsured. It didn't strike the individual mandate. It zeroed out the penalty for not having insurance. Their argument is no penalty, no individual mandate, no Affordable Care Act. They're trying to argue that there's this severability issue at play. You can't sever the tax penalty from the individual mandate. You can't sever the individual mandate from the Affordable Care Act. It's a cluster of a statute, and it either is all here or it's all gone. That's their argument. Health policy experts and legal scholars have said that's a really weak argument. That really shouldn't even get through the front door of most courts. But we're in a very conservative court here, so that could have an impact. The plaintiffs want to enjoin the feds. They want to stop the feds, both Health and Human Services and the IRS, from enforcing the entire Affordable Care Act. They say, at the very least, strike the individual mandate, strike guarantee issue, and strike community rating provisions. Get rid of that. They want the judge to issue a preliminary injunction to get rid of the Affordable Care Act before 2019, before the next plan year. So people will be buying insurance in open enrollment November 1st through December 15th, and the plaintiff states want this to not be around by January 1st, 2019. So before open enrollment, before the next plan year starts, they want the judge to issue his preliminary injunction or to stop the Affordable Care Act from happening. At the very least, they want the injunction issued for the 20 states that signed on to this lawsuit. They said they're kind of hedging their bets a little bit and say, hey, maybe you don't want to scrap it for everybody, but scrap it for us, the 20 states that don't like the Affordable Care Act. Now, the Department of Justice joined into this lawsuit defending the 20 plaintiff states that want to get rid of the Affordable Care Act. They're not defending the Affordable Care Act, the law of the land, as most departments of justice would do. They're defending the 20 states that want to get rid of the Affordable Care Act. Their take is just a little different. They refused to defend the Affordable Care Act. They called the Affordable Care Act's individual mandate unconstitutional, so that's where they're in agreement with the 20 states. They asked for a declaratory judgment, though. They want the timing to be different. They don't want an injunction. They don't want this thing struck before open enrollment and before 2019, because they said that would throw the markets into chaos if we had this preliminary injunction in the fall. Instead, they said issue a declaratory judgment that says, this is no good, and then deal with it later. The Department of Justice said it's actually okay that the rest of the Affordable Care Act remain intact. Strike the individual mandate. They're arguing a little bit different than that severability argument. They said strike this piece and do that later. That's where the Department of Justice stands. Where does the case stand overall? Well, the hearing for the motion on a preliminary injunction was September 5th. It went in front of Judge O'Connor. A ruling could come at any time. So we're in limbo now while the judge decides. He said he will decide as quickly as he can, but he's got a couple options. He could decide to strike the entire Affordable Care Act. He could decide to uphold the entire Affordable Care Act, or he could do some of the following. He could strike only the individual mandate. He could agree with the Department of Justice, and then he could decide what the timing would be on that. He could strike down the individual mandate and other provisions that are deemed inseverable from the individual mandate. He could also limit an injunction to just those 20 states in any of these variations. So in any event, if this happens, a lawsuit is likely to be repealed, but it does go first to that Fifth Circuit Court of Appeals. Very conservative Fifth Circuit Court of Appeals. it could end up potentially at the U.S. Supreme Court if it got appealed there. That's why the composition of the U.S. Supreme Court, as being argued right now in front of Congress, is very important for a number of reasons, but also potentially for this case. If any part of the Affordable Care Act is struck down, the intervener states, those states that want to uphold the Affordable Care Act, are likely to request a stay of an injunction while it's being appealed. They don't want an injunction to take effect and then have the Affordable Care Act be halted. They said even if you do issue an injunction, we want to stay where that the Affordable Care Act is still in effect. The injunction doesn't take effect right away. We want the Affordable Care Act to stay in effect as the appeals are happening. That just buys time, and time is their friend. You can read a couple blog posts, you can read some Department of Justice responses to the court, and some letters going back and forth among congressional leaders, and you can read that here. You could also visit our website, healthwatchwisconsin.org, and learn more. Thanks for watching.